Hi, everybody. Welcome to our solo webinar. We hold these webinars every Wednesday evening where we answer your questions about debt and debt collection. We're really excited for this evening's webinar because we have a special guest, Greg Anjewierden. Greg is the owner and CEO of Debtbrief, which is a debt resolution company that can help you if you've been sued for debt. And he's also an attorney, so he's got lots of experience in this world of debt and medical debt, especially because, correct me if I'm wrong, Greg, but I believe you used to do medical debt collections for a law firm. But yeah, I wanted to give some time briefly to Greg to introduce himself. Also, I should probably introduce myself. I'm Hannah Locklear. I'm on the solo team, and we have a mission to help people resolve debts and settle their debts, especially if they've been sued. So with that being said, wanted to give you a moment, Greg, to introduce yourself. Tell us a little bit about Debtbrief and your experience in the debt collection industry.
Thanks. I'm Greg Anjewierden. I do have a company, Debtbrief. I did used to do a lot of debt collection for medical providers. I've sort of shifted my focus now, started this company, Debtbrief. So now I provide resources to people that are being sued by debt collectors that when maybe they can't afford an attorney, like I've got other options for them, helping them with forms and coaching, and which is why I'm helping out with Solo here, because I really believe in their mission and what they do, and really fighting back against the debt collectors and giving yourself the best chance you've got against them.
Awesome. Thank you so much, Greg, again for joining. It's great to have you. Greg has awesome perspective and insights into this debt collection process. And so if anyone is watching, we want you to go ahead and submit your questions on the chat. We'll be starting to respond to those questions live here in just a moment. We do have a few preliminary questions that I wanted to ask Greg as an expert in this space. And so, yeah, I see we have a few questions already getting submitted, but yeah, go on and submit your questions and we'll get to those in just a moment. So Greg, I guess to kick off this webinar, wanted to ask you a little bit about medical debt. As the title implies, Medical Debt 101, How to Protect Your Finances and Credit If You Owe Medical Debt. So my first question for you is, does medical debt affect your credit score?
So I'm going to have maybe a long answer on this. It definitely can affect your credit score, right? So if that medical debt ends up on your credit report, it's going to affect the credit score. Now, sometimes with some of these credit bureaus, they might weigh medical debt less than other types of debt. And that makes sense, right? Because, if you get in an accident and you have to go to the hospital and you have this big bill that you can't afford to pay, that's kind of different in measuring your credit worthiness, as opposed to somebody who went out and got a credit card and just went shopping and spent like $10,000 and didn't pay it back, right? Like those are two different kinds of things. And so I think the medical debt can be weighed less than some of that consumer debt, but it can still affect it. There's other recent rules that have been changed. So I think the threshold now is $500 if it's medical debt under $500 now. I believe it's not reportable to the credit bureaus anymore. I'm not exactly positive on that exact amount just off the top of my head, but I'm pretty sure that that's correct.
And really
so that could be an effect as well.
Yeah, to give some insight too, from what I understand, the Consumer Financial Protection Bureau, which is a federal agency that helps protect consumers who are dealing with debt. It is actually right now a little uncertain what the future of that agency will be because of the new presidency and the new Trump administration. They have made some executive orders to shut down the agency, which would leave consumer rights and consumer protection rights kind of up in the air. And so the whole future of that is a little bit uncertain, but last year, one of the big moves that the Consumer Financial Protection Bureau was trying to make was to prevent medical debt reporting on credit reports. So that was a big one. And I think you're right, Greg, like if your medical debt is $500 or less, usually it would not appear on your credit report at all. But that was a big push that the CFPB was making, was to prevent medical debt from being a part of the credit report at all. But with the new Trump administration, things are a little bit up in the air for now, because we don't even know how much longer the CFPB will continue to exist, if it does. Hopefully it will exist, because I do think that it can help protect consumers to a certain extent. But yeah, things are a little bit crazy right now in terms of medical debt and credit reporting. So
Yeah, and I want to add one thing to that. I agree with everything you said. It definitely is in flux. The other thing that I see in regard to medical debt and credit reporting that most people don't understand is that the credit reporting is different than the debt collecting, right? Like the credit reporting is just like, okay, this stuff gets reported, and that credit score helps you determine what kind of interest rates you can get, what kind of loans you can get, etc. Even if the medical debt is not on the credit report, it is still collectible. They can still take you to court, right? So I don't want people to get confused and be like, oh, good, it's not going on my credit report, I can get away with not paying this. Oh no, they will still sue you and come after that money, even if it is not reportable, or even if it is reportable and it's not on the credit report. So that's, I think, an important distinction to make when it comes to medical debt and credit reporting as well.
oh yeah, I completely agree. Like, even if it doesn't affect your credit, it doesn't mean that it won't affect you legally, and there can still be repercussions if you don't pay the medical debt. So that's a really great point to point out. So thank you for that. My next question is very much related to this, and it is, how long does medical debt typically stay on your credit report?
Yeah, I think this one, like most debt, stuff cycles off that credit report every 7 years. So it's going to be on there now. So you can, I guess, make the decision like, I'll just wait it out, and after 7 years it's going to come off. You can go to the credit bureaus and try and show them that you don't owe this debt, or that maybe shouldn't be on there, and get it removed. You can get it removed sooner in that regard. I believe one of those rules that the Consumer Financial Protection Bureau has made recently is that if the medical debt is paid, it gets removed. So a lot of times with other debt, like consumer debts, if it gets paid late, or if it gets paid in part, or it's settled, there's like a notation made that it wasn't just paid in full on time. But I believe with medical debts, even if it's paid late, like you can get it removed in that way for medical specific debts.
Yeah, because like you said, like medical debt is just different in nature compared to credit card debts, where you're intentionally going out and spending money. Whereas with medical debt, oftentimes it's an unexpected expense that you have to incur. So that's a very good point as well. And I think it also depends. I think there are a lot of factors that will influence like how much it will affect your credit report, like perhaps the amount of debt, correct? Would you say that's true?
How it will affect your credit report?
Well, like, does the amount of medical debt that you owe affect your credit report differently? Like if you owe a lot, for example, versus maybe a few $100s, do you think it makes a difference on?
I mean, I don't know the answer to that for certain in regard to medical debt on a credit report. My guess is that on medical debt, it's just going to be weighed less. Probably the amount is less important, as opposed to consumer debt, where the amount definitely matters in consumer debt on your credit report. Probably less so on medical debt.
Okay, yeah, that's a good point. All right. Well, next question is, and this is the last question, I think, before we'll open it up to our live questions being submitted on the chat. Again, if you're watching, thanks so much for being here, and please go ahead and start submitting your questions. We'll get to those in just a moment. The last question, though, I have for you, Greg, is what is the smartest way to negotiate medical debt? Because according to my understanding, it is a bit of a different game than negotiating credit card debt or other types of debt. So what, in your opinion, is the best way to negotiate specifically medical debt?
Okay, so the first thing I'll say, this is not going to be across the board, but there are a lot of medical providers that understand the issue with medical debt, right? Like even if you've got insurance, maybe you've got like a high deductible plan or whatever, you could still get up to like a $10,000 bill if you have some emergency surgery or something, right? So I think the first thing that you want to do is reach out to that specific provider and see if they have any kind of charity plans, or even if you might not qualify for a charity plan, you might still be able to get on an interest-free payment plan. A lot of medical providers, especially hospitals, will do that. Maybe they'll say like, for 3 months or 5 months, we'll spread this out, no interest, you can pay it. So I think that is the first thing you should do, is see if your specific medical provider, will will give you some kind of plan like that. But let's say you're kind of past that point, hasn't been paid, you couldn't pay it, you're now being sued. I think the best thing you can do at this point is, first of all, you need to engage in the defense of your case, right? So that's like using solo suit to file your answer so you don't get a default judgment. And then just start engaging in the case and defending the case as the best way you can, which is going to give you a little bit of leverage to negotiate. Because once they see that, like, look, you're engaged, you're not rolling over, you're going to fight this, they've got to spend some time. At this point, you can reach out and, start to negotiate the debt. You can also use solo settle, which is a really great tool, so that, maybe you don't feel comfortable negotiating with the attorney for the hospital or the doctor or whoever. And solo settle is going to be a really great way to do that. But I think what you need to do is you need to be engaged in the defense of the case, and then find your points of leverage and then negotiate from there.
Yeah, I think that those are a lot of really good points. And I would say and want to emphasize the fact that you really need to engage. Like, if you're being contacted about a medical debt, or if you've been sued, the worst thing that you can do is ignore it, because it's not going to go away. And ignoring it could lead to bigger problems like wage garnishment, liens on your property, other things like that. So the most important thing that you can do if you're being contacted by a debt collector is communicate with them, like engage with them. And in many cases, they will work with you. But yeah, that's just the first step, is just make sure that you do not ignore it.
So I want to add a caveat to that, though. I think it's okay to ignore in certain circumstances if you're strategically doing so. And let me give you an example. So maybe they're just going to be contacting you and pestering you first, right? And you respond to them and you try and negotiate something. They're not coming to a number that you're okay with or that you are capable of paying, haven't been sued yet. I think at that point, you could strategically say, look, I'm cutting off the communication with you. And because they can't garnish your wages or any of these things unless they take you to court. You've already engaged, you've already tried to settle. At that point, I think it might be okay in some circumstances to cut off the communication, wait for them to sue you, and then reinitiate the communication, because you've given yourself a little bit of leverage again. They've had to sue you, they're having to spend more time and more money, and you answer, so they're not going to get a default judgment. Now you re-engage at that point. I think that's actually a good strategy.
So let me get this clear. Like, if you've reached out and you've tried to negotiate and it's not going anywhere, you're not finding an agreement, you can stop communications for a bit, see if they take legal action, and if they do, then file a response to defend yourself. At that point, I guess, like, where could it potentially go from there? Like, if the debt really is valid and you do owe it, do you feel like after they file a lawsuit, it's easier to settle? Is that what you're saying for medical debt specifically?
I think a lot of times it is. This isn't going to qualify for every single person in every situation, right? But I think it is a little easier to settle at that point. And for a couple reasons. First, before they file suit, you're probably dealing with like a debt collector, right? What you think is a debt collector, some person calling you and harassing you, right? Those people can be difficult to negotiate and deal with. And in my experience, it is usually easier to negotiate with an attorney. And the reason for that is the attorney is going to be busy. Their job isn't necessarily to pester you. Their job is to get the money, right? And the attorney doesn't want to go spend a full day in court in a trial with you to prove that you owe this. They don't want to spend a half a day drafting a motion for summary judgment to get this money from you. Like, they are looking at it very economically in comparison with their time. So once you can get an attorney involved, I've found you can usually get a better deal in negotiating a settlement.
So it might actually be easier in some ways to negotiate with the attorney because they just want to get the money and they don't want to spend a lot of extra time negotiating, playing phone tag, putting you on hold while they figure things out. They just want to have a straightforward conversation where they can settle before they actually have to show up in court and fight it in court.
Right. And that's why it's important for you to file your answer, right? And engage in the case, because every time you're filing something, they're spending time. And if you're showing them, look, I'm going to spend all this time on this case, they're saying like, oh, this is not how I wanted this to go. I wanted a quick default judgment and a wage garnishment. So they may be willing to work with you more on that number so that they can spend less time on you and move on to the next person that's not doing what you're doing.
Very interesting. I think that's a good point. I mean, especially if you've been sued, it's always smart to file your answer. I've actually just shared a link to where you can draft and file an answer on our website, solosuit.com. Our software can help you personalize your answer so that it fits your case details. And it also will provide you with the proper legal language that you need to be able to defend yourself. And then we also help you file it with the courts. So we can help file and draft an answer in all 50 states. So head on over to the link. I'll drop it in the chat one more time just so that it's right there at the top. But yeah, that's a really good move. Always, if you've been sued, definitely always want to file an answer to avoid the default judgment. Awesome. Well, yeah, that was a really great perspective. I don't think I've ever really heard, or it was a new perspective for me, Greg, to hear that in some cases it could be good to stop communications if you're not getting anywhere with it, and then wait for the lawsuit to be filed, because then once you negotiate with a lawyer, they just want a quick settlement. So that's a very interesting perspective. Thank you for sharing. Well, with that, I think it would be a good time then to open up for questions for our viewers. We have a few submitted here on the chat, so I'll go ahead and read those out loud, and then Greg, we'd love to hear your thoughts on those questions. First is from Wilbur. It says, hello, can a debt collector come after my Social Security and the small pension that I get?
So on the Social Security, no. Social Security is typically protected. And probably not on the pension as well, but there's a caveat to that, right? Like, it's not going to be like a wage garnishment where they go and just take the Social Security before you can get it, right? Like if your wages are garnished, they go to your employer and that money is taken away before it ever gets to your paycheck. But if you take that money and then you like hold it in a bank account, you've just got like a checking account, say, they could potentially do like a bank levy or a bank garnishment, and they'll do that. And it's a little bit different than a wage garnishment because it doesn't always just like they just take it every time it hits it. But usually in most states, the way it's going to be is they get that bank levy and they do it on the bank, and then the bank just goes and takes, boom, everything out of the bank account minus what they're statutorily required to keep there in your state. And then like the rest of that money's gone and goes to the collector. So like, no, they're not going to take your Social Security, but depending on how you, I guess, store or save your money, they could still potentially try and get at it, if that makes sense. So you got to be careful about where you're keeping your money. And these are all going to be different laws depending on the state as how much has to be left in there, whether they can take it out of the bank, et cetera. But you don't have to worry about your Social Security not making it to you, but you do need to worry about keeping that money safe once you get it.
Awesome. Yeah. And according to my understanding, in most states, but again, like Greg said, every state is different. Every state has unique laws. But in most states, most Social Security income is protected from wage garnishment. So, but I do think it's important to, if you have other funds or savings, like to make sure you're watching those and be careful where you put your money. Okay, let's see. Next question on the chat is from Noel. It says, wasn't there a recent ruling weakening medical debt collection standards? I'm going to drop a quick resource from the CFPB's website. On January 7th of this year, the CFPB, it looks like they finalized their rule to remove medical bills from credit reports. So that was kind of what we were discussing earlier. This might be a good resource for you, Noel, to get you an answer to your question. But yeah, Greg, do you know anything off the top of your head about that?
Say that question to me one more time.
Yeah, so wasn't there a recent ruling weakening medical debt collection standards?
Yeah, so I don't know of any ruling weakening collection standards. And so I'm not entirely positive what this person is asking. So if I'm getting this wrong, let me know. But what what I think she's probably saying is exactly what we were talking about earlier, where it has weakened what medical debt can go into your credit report. But the credit reporting is different than the collections part of it. So I'm not aware of any ruling that has actually weakened the collections part of it. I'm only aware of the ruling that has weakened the credit reporting part of it.
And that's kind of, I would agree. I haven't heard of anything that like prohibits specific medical debt collection practices, but the credit reporting, definitely there's been a lot of action taken by the CFPB to prevent that. So yeah, we dropped that resource in the chat. But again, remember the Trump administration recently moved to disband the CFPB, and everything regarding that is a little bit up in the air right now. And I'm not sure how it will affect their recent ruling to ban medical debt on credit reports. So we'll have to, I guess, wait and see what happens there. Let's see. Next question is from Mel. It says, I've heard that the CFPB will stop the whole medical debt reporting due to new leadership, but is it true that California residents will not have medical debt despite the changes? I think this is a similar question to the previous one, and I think the resource that I shared would probably be helpful in finding the answer to that. Do you have any thoughts, Greg, though?
That's my same thing. And I really, it is something that I encounter every time I talk to somebody about credit reporting. I mean, I can't tell you how many times I get the question like, well, it's not on my credit report. Why are they suing me? Right? Like, you got to remember that credit reporting and debt collecting are two separate things that are happening in regard to the same debt, but they're two like different processes. So yeah, I'm not aware of anything that says in California they can't collect medical debt from you. Maybe there's something new that I haven't heard of, but I haven't heard anything like that.
Yeah, and I'm gonna just drop another resource in the chat regarding this question for you, Mel. Hi Mel, thank you for watching. Mel's one of our partners, and yeah, thank you so much for watching, Mel. But I am dropping a resource in the chat on that too. It's from the Department of Financial Protection and Innovation for the state of California. From what I can tell, there are some protections in place for consumers when it comes to medical debt. And this outlines some of those protections. Some of them involve like reduced medical care, like the cost can be reduced if you are eligible in certain instances. The credit reporting time frame, so the amount of time that hospitals have to report your debt to the credit bureaus, if they're still able to do that, etc. But this outlines some of those, and it might answer your question, Mel.
And I want to add too, like this goes to what we were talking about earlier as to when you asked the question, the smartest way to negotiate medical debt, right? And I brought up there may be certain charity programs and things. And, in California, there are going to be some, like income limits and things and surprise bills where maybe you don't have to pay them. And so just generally across the board, can we say that like medical bills can't be collected in California? No. But based on your income and your situation, there might be some things that would allow you to get out of paying that bill. And that would be a case specific thing for you that, you'd need to research. If that makes sense.
Yeah, and I think there's so many factors that are at play that oftentimes it is a case-by-case situation, and you have to do some research depending on the factors of your particular case before you'll know really what the answer is. I also wanted to say, just from a personal experience, I had a baby a couple of years ago, and as a part of that, I incurred some medical debt because of the services that were provided during the birth. And things got a little crazy with my insurance. But one thing that I learned throughout the process of, having my first big medical bill, was that if you reach out to the hospital and offer them like a lump sum payment up front, so instead of setting up a payment plan, like if you have some money saved up and you want to just kind of get rid of the debt, you can often offer to settle for like, I don't know, a percentage of the full amount, maybe like 60 to 80%. And just say, hey, I can pay this off today if you'll cut the cost down for me. And oftentimes hospitals will work with you to accept less than the full amount. That's not always possible for everyone. So I didn't do that personally in my case because I didn't have like hundreds of dollars to give right away. But I do think that that's an option if you are dealing with medical debt and you just want to like resolve it and be done with it. Some hospitals will accept a percentage up front if you can pay a lump sum. All right, let's see. Next question is from Savage San. Hello there. It says, what if they file a motion for summary judgment and then you want to negotiate for settlement, but they don't want to settle for less than 80%? How should I proceed with negotiation if the debt is $6,000? So it sounds like maybe you've been sued and the plaintiff has filed a motion for summary judgment. You're being sued for $6,000 and you're trying to negotiate after the summary judgment motion has been filed, and you're trying to get them to settle for less than 80%. Greg, any tips on negotiating this?
Yeah, definitely. Okay. So, you can always control what you do on the case. You cannot, and you can control like the settlement offers you make. You can't control how far they come down, right? So some medical providers or debt collectors, whoever, are going to come down a lot for you. Some of them might say, we're not coming down below 80%. Like, we will not. Or I've seen some where they're just like, we will not take anything less than the full amount. Like, we will not negotiate with you. Like, it happens, right? Now you're faced with a motion for summary judgment. You can't settle it. So what do? I think the first thing you got to do is you need to fight that motion for summary judgment, right? And summary judgment means they've laid out the facts in their motion and they say, hey, the defendant doesn't dispute any of these facts. And so, judge, we don't need to have a trial to determine who's telling the truth. Just look at these facts and tell us if they owe or not. And then the judge rules and enters judgment or not. To defeat a motion for summary judgment, you file a memorandum in opposition. And the key to winning that is you need to show that their facts are different than your facts, right? You need to turn it into like a he said, she said. So if the judge looks at it and says, well, the debt collector's saying this, but the defendant is saying something different, and I can't decide who's telling the truth, so I have to deny the motion for summary judgment, and then we'll set the case for trial. So if you can defeat that motion for summary judgment, it is likely that they will come down from that 80% number, because now they have to go to trial. They're going to have to bring a witness who can testify to the authenticity of the documents and things, right? It's just going to be so much more work and money for them. So you will likely get them to come down a number if you can defeat the motion for summary judgment. Now, if you owe the money and they've got all the proof in that motion, it can be hard to defeat a motion for summary judgment, right? So then you say, well, how do I get it down if I can't defeat it? You're going to fight it as best you can, file the opposition, try and re-engage to negotiate. They still won't come down. You're going to fight that motion all the way through. Now, let's say the judge enters summary judgment against you. You don't get a trial. You've lost the case. They now have a judgment. You got to remember that a case can be settled at any time, including after judgment is entered. So you fight that summary judgment, you lose, they have a summary judgment against you, they've still got to get the money from you. So maybe at this point, if you have a W-2 income, they can garnish your wages, but they're going to be limited to 25% of your take-home pay. That's not going to be probably a lot. And so maybe you can give them an offer to incentivize them, like we just talked about with the hospital. They'll give them a bigger lump sum so they don't have to chase it down every month. If your employment isn't secure, go find another job and make them chase you from job to job. Or maybe you work for yourself, you don't get a W-2 income, they can't garnish your wages. Maybe you're hiding your money in different bank accounts, or you put the money in a bank account for your spouse. It's just hard for them to get the money. Now you can re-engage and say, you already have the judgment, but you don't have the money. So now maybe they're willing to come down because they've seen that it's harder to get the money out of you. So I don't know, that's kind of a long answer, but I think what you want to do is you always want to fight and continue to negotiate while you're fighting up until the point where you lose, and then you still keep negotiating. And the worst thing that can happen is they get the judgment, they garnish your wages, they take 25% of your take-home pay until they hit the $6,000.
Okay, I feel like that was a really helpful answer. We did get into the legal realm a little bit, and so I just wanted to give a disclaimer that yes, Greg is an attorney, and Solo, we offer legal resources, but none of this constitutes as like actual legal advice because we're not your attorney, and we can't give you legal advice if we don't represent you. So I just wanted to make sure we put out that disclaimer. I probably should have said that in the beginning, but this is extremely helpful because what I love what you said, Greg, is that you can negotiate a settlement at any stage of the process, even after a judgment is filed. Even after you've lost the case, you can still negotiate because it might make it easier for the law firm and the collector to get the money if they settle instead of having to go through the whole garnishment process. So don't give up hope because a motion for summary judgment has been filed against you. There are still lots of opportunities for you to settle. And I would also add that if that has been filed in the case, the motion for summary judgment, and they're willing to accept 80% settlement, in some cases that might actually be like a really fair and good settlement. So you might consider, accepting it. All right. Well, I think that is going to be our last question for the evening. We're going to go ahead and wrap up, but Greg, did you have any other things that you wanted to say about Debtbrief or the debt resolution process?
Yeah, so you can find all of my stuff at debtbrief.com. Again, I know Solo is really good if you need to file an answer. I highly recommend Solo Settle if you want to try and negotiate your debt. What I do at Debtbrief is I've got some of these other forms that you can have there. For example, you need to file an opposition to a motion for summary judgment. You can find that form at debtbrief.com, as well as I do like one-on-one consultations where I provide instructions, sort of a one-on-one class where I teach you how to take the case from beginning to end. So you can find all that information at debtbrief.com.
Awesome. I just shared the Debtbrief website on the chat, so go ahead and check that out. I'll drop the link to use Solo to draft and file your answer to the lawsuit and negotiate with the Solo Settle platform. So yeah, if you guys have any questions, feel free to reach out to us at support@solosuit.com. We're happy to answer your questions and try to point you in the right direction. And again, we hold these webinars every Wednesday evening. So tune in next week because we'll have a new topic and a new guest speaker. But Greg, I want to say huge thank you for your perspective, for sharing your experience and answering these questions and doing so very helpfully. So thank you so much.
Thank you, and thanks to Solo for having me.
Thanks everybody for watching. Have a great